This is the case of Kilmar Armando Abrego Garcia, and anybody that's paying attention is truly, truly horrified. Because let's say he was here illegally, which he's not. He was here legally, and I'm going to show you exactly why and how. But let's say he wasn't here legally. We still have due process in America. That's what makes America a democracy and makes it a better place to be, because you are innocent until proven guilty in a court of law. Everybody. That includes everyone. That's what makes us amazing and makes us special. Okay. So what they're saying is that he was part of M13. I've seen M16, 18. I don't even know what that gang is, but I think it's M13 that you guys are trying to say that he was a part of. Now, this is actually the court case in 2019. There's another court case going around. I'm going to read you the case and what was proven to be true by the judge. This is by the judge. This is on Court Listener. You can go look up different cases on Court Listener. First, I'm going to start on Wikipedia here, which I find really interesting. So here's the story of Kilmar Armando Abrego Garcia. So he was born in San Salvador. The Barrio 18 gang allegedly tried to extort his mom's pupusa business for money. Now, that's what's in this court document here. This is what we're going to talk about here in a minute. But what I found interesting was he fled and he came into the U.S. illegally at age 16. He was only 16, guys. He was not an adult. He was 16 years old when he got here in 2011. And then in 2016, he met his wife, a U.S. citizen, and he married her. In March of 2019, police actually arrested him and 3 other men in a Home Depot parking lot where they were seeking work as day laborers. And one of the men claimed that Abrego was a gang member. But the Atlantic reported that, according to court filings, the man offered no proof, and the police said they didn't believe him. So he was never charged with a crime in connection to that arrest. Okay, guys, there's no crime. There's nothing in there, right? So police handed custody of Abrego Garcia over to the ICE for deportation proceedings. But in those proceedings, the government did claim that he was a member of MS-13 because he was wearing a Chicago's Bulls hat and a hoodie. And a confidential informant claimed that he was active with the MS-13 group that was based in New York, but he never lived in New York. So he never lived in that location. But ICE relied on the information from a form that was filled out by a local police officer who was suspended not long after for giving confidential information about a case to a sex worker. And he was unavailable when Abrego Garcia's lawyer sought more information. So Roger Parloff of Lawfare notes that since neither the officer nor the informant were cross-examined, the accusation went through 2 layers of hearsay to reach the immigration court. And an immigration court determined that the informant's claim was sufficient evidence to propose the denying Abrego Garcia's bond request. But then another judge upheld the ruling on appeal, saying the claim was not clearly wrong. So the court never made a full adjudication of the issue, but he was deemed that he was not. He's consistently denied that he's MS-13. He is not MS-13. There's nothing in any court filings that say he was. He was accused, but there's nothing in the court filing that says he was. So the government statement is assumed true, and the burden of proof then lands on the defendant. So that's kind of how that does work. So so here's the actual case, and we'll go ahead and read this. So the respondent is a native and citizen of El Salvador. The Department of Homeland Security issued the respondent a notice to appear on March 29, 2019, which alleged that the respondent is not a citizen of the national United States, and he's a native and citizen of El Salvador, and he'd entered the United States at or near an unknown place on or about an unknown date, and was then admitted or paroled after inspection by an immigration officer. At a master calendar hearing, the respondent, through counsel, admitted the factual allegations contained in the NTA and conceded removability as charged. And based on the respondent's admission and concessions, the court found his removability to be established by clear and convincing evidence required by INA. So As relief from removal, the respondent filed a Form I-589, application for asylum, withholding of removal, and relief under Article 3 of the Convention Against Torture. The respondent and his wife both testified in support of the applications, and the court reserved the matter for the issuance of a written decision. The court has considered the arguments of both parties and the entire record carefully. The following documentary evidence was considered by the court and admitted into record. Exhibit 1, the notice to appear. Exhibit 2, the I-2213. Exhibit 3, the respondent's application with all supporting documents. And Exhibit 5, Part A, explanation of the wife's pregnant condition while testifying. All evidence and testimony admitted has been considered, even if not specifically addressed in the decision. Having reviewed the evidence of record and the applicable law, the court's written decision and order now follow. So he goes into his history, and I'll go ahead and go into the history, and then I'll jump to the ruling, because the ruling is going to show you that he was ruled to be legally in the United States. He's legally here. He was not here illegally. And if he was MS-13, the judge would never have ruled him to be allowed to stay, by the way. Okay, the respondent is a 24-year-old native of El Salvador. He was born in 1995 in Los Nogales, and I might be butchering that name, neighborhood San Salvador, El Salvador. The respondent testified that he fears returning to his country because the Barrio 18 gang was targeting him and threatening him with death because of his family's pupusa business. I had to go look up what pupusas are. They look delicious. The respondent's mother, Cecilia, ran the business out of her home. Although the business had no formal storefront, everyone in the town knew to get their pupusas from Pupuseria Cecilia. The respondent's father, brother, and 2 sisters all helped run the family business. The respondent's job was to go to the grocery store to buy the supplies needed for the pupusas, and then he and his brother would go do deliveries 4 days a week to the people in the town that order pupusas from Cecilia. Let's go read this Exhibit 4. Exhibit 4 is a Prince George's County Police Department gang field interview sheet. It was admitted for limited purpose of showing that the respondent was labeled a gang member by law enforcement. And then El Salvadorian stuffed tortillas. That's what pupusas are. Stuffed tortillas. So at some point, Barrio 18 realized that the family was making money from their family business, and they began extorting the respondent's mother, Cecilia. They demanded a regular stipend of rent money from the business, beginning with a monthly payment and then requiring weekly payments. The gang threatened to harm the respondent, his older brother Caesar, and the family in general if their demands were not met. Alternatively, they told Cecilia, that's his mom, that if she could not pay the extortion money, she could turn Caesar over to them to become part of their gang. The Abrego family paid the money on a regular basis whenever they could and hid Caesar from the gang. On one occasion, the gang came to the family's home and threatened to kill Caesar if the family did not pay the rent. The family responded by sending Caesar to the U.S. After Caesar left, the gang started recruiting the respondent. They told Cecilia that she would not have to pay rent anymore if she let him join the gang. The mother refused to let this happen. The gang then threatened to kill the respondent. And when the respondent was around 12 years old, the gang came to the home again, telling Cecilia that they would take him because she wasn't paying money from the family's pupusa business. The respondent's father prevented the gang from taking the respondent that day by paying the gang all the money that they wanted. During the days, the gang would watch the respondent when he went back and forth to school, and the members of the gangs all had many tattoos, and they always carried weapons. Eventually, the family had enough and moved from Los Nogales to the 10th of October neighborhood. I do not know what any of that is. This town was about 10 minutes away by car from Los Nogales, and I might be saying that wrong again. Sorry, I apologize to the El Salvadorians. Shortly after the family moved, members of Barrio 18 from Nogales went to the 10th of October and let their fellow gang members know that the family had moved to that neighborhood. Barrio 18 members visited the house demanding the rent money from the pupusa business again. They went to the house twice, threatening to assault and harm the respondent's 2 sisters and threatening the respondent. The respondent's parents were so fearful that they kept the respondent inside the home as much as possible. Finally, the family decided they had to close the pupusa business and move to another area, Los Andes, about a 15-minute drive from their last residence. Even at this new location, the family kept the respondent indoors most of the time because of the threats on his life. After 4 months of living in fear, the respondent's parents sent the respondent to the U.S. So they sent him to the U.S. at age 16. This guy was a kid, you guys. He was a kid. Even though the respondent's father was a former policeman, they family never reported anything to the police regarding the gang extorting the family business. The gang members had threatened Cecilia, telling her that if she ever reported anything to the police, they would kill her entire family. The family believed them because they were well aware of the rampant corruption of the police in El Salvador, and they believed that if they reported it to the police would do nothing. At present, even though the family has now shut down the pupusa business, Barrio 18 continues to harass and threaten the respondents' two sisters and parents in Guatemala. Additionally, they have targeted a brother-in-law who now lives with the family. The respondent's wife also testified, but her testimony related to two other particular social groups not reached in this decision. Eligibility for asylum, withholding the CAT relief. An applicant for asylum bears the burden of establishing that he meets the definition of a refugee under INA, which defines a refugee in part as an alien who is unable or unwilling to return to her home because of persecution or a well-founded fear of prosecution on account of race, religion, nationality, membership in a particular social group, or political opinion. The alien's fear of persecution must be countrywide, matter of acosta. Additionally, the alien must establish that he is unable or unwilling to avail himself of the protection of his country or nationality or last habitual resident. An applicant who establishes statutory eligibility for asylum still bears the burden of demonstrating that he merits a grant of asylum as a matter of discretion. So what this basically kind of means is for asylum to be granted asylum, you can't just fear being in the country because of gang members. It has to be the government that's going to harm you. So if you're going to claim refugee status or asylum status in another country, it has to be the government that's persecuting you. So that's kind of what that means. So I'm just going to jump down to the ruling. And they did the filing deadline. They did the withholding of removal pursuant. And the burden of proof lands on the person of the past persecution. So here it says persecution has been interpreted to include serious threats to an individual life or freedom or the infliction of significant harm on the applicant. Persecution is generally assessed cumulatively and relevant incidents are not to be evaluated in isolation. A death threat qualifies as persecution. Extortion may constitute persecution even if physical harm will be inflicted upon failure to pay. The respondent suffered past persecution as he was threatened with death on one or more occasions. Therefore, DHS bears the burden of establishing a fundamental change in circumstances such that the applicant's life or freedom would not be threatened on account of any of the 5 grounds, or that the applicant could avoid a future threat to his or her life or freedom by relocating to another part of the proposed country, or removal, and or under all the circumstances, it would be reasonable to expect the application to do so. So in the so the well-founded fear, nexus to protected ground. So let's get to the ruling. I'll get to the basic ruling. So they didn't find that the government was going to actually, here's the conclusion. So the respondent's application for assignment is time barred without exception. However, he has established past persecution based on a protected ground and the presumption of a well-founded fear of future persecution. DHS has not shown that there are changes circumstances in Guatemala that would result in the respondent's life not being threatened, or that internal relocation is possible and reasonable under the circumstances. Therefore, the respondent's application for withholding under the Act is granted. But his CAT claim failed because he's not shown that he would suffer torture. That's by the government. So the CAT claim failed because the torture is not by the government, but that he was granted asylum for fear of persecution. So it's hereby ordered that the respondent's application for asylum pursuant to INA is denied, but the respondent's application for withholding of removal pursuant to INA is granted, right? Because they couldn't prove that the government would be the one that would be torturing him or harming him. So even though it is now, because he is currently sitting in a prison that is actually a concentration camp. And I just found this was interesting. This is according to the Holocaust Encyclopedia. The Holocaust Encyclopedia makes this distinction. What distinguishes a concentration camp from a prison in the modern sense is that it functions outside of a judicial system. So the prisoners are not indicted or convicted of any crime by judicial process, meaning they were just thrown in there with no due process. And this is what was happened to this guy. And he was legally here. And what is the most horrifying to me is that his wife would not even know where he is right now if she hadn't seen his head shaved and him paraded around on TV. Like, that is horrific. Like, I just cannot even imagine what that wife is going through, seeing her husband like that. I can't imagine what the husband's going through. She must be scared out of her mind if he's even still alive or not. We don't know that we don't know. And right now, a judge has ordered him to get that guy returned. A judge has ordered Trump to return, and we can go into those cases as well and read them. But Donald Trump, he, in a court ruling, he admitted that they made a mistake and that he was legally here. So the Trump administration acknowledges that mistake. So the court said, okay, well, you made a mistake. That's okay. Get him back. And right now he's completely defying the court order and lying on TV, but not in court. This should scare the living crap out of absolutely everyone.